I'll just get all of the housekeeping issues out of the way. There are no anticipated fire alarms, so if there is a fire alarm, you're asked to kindly make your way out of these doors, left and right, and there'll be a steward to guide you to the nearest exit. If you are using Twitter, then there is a hashtag for this event, which is LSE Women Work with capital W's. And the event will be podcast, presuming we have no technical glitches. So keep that in mind, and I'd ask you to turn off your phones or turn them onto silent now, if you wouldn't mind, so as not to disrupt our speaker this evening. There will be time at the end of the event for some questions to our speaker, and as this is a celebration this evening, there'll also be a drinks reception outside after the event. So, I guess without further ado, this is the last in this year-long series on women at work, which has been a commemoration of 100 years since the Sex Disqualification Removal Act. So you're going to hear a lot more about this act this evening, but it removed legal barriers of sex and marriage from official appointments and professional occupations, including the legal occupation. And so this event is co-hosted by the LSE's Women's Library. So if you haven't been yet, the LSE Women's Library is an incredibly rich source of information about women's campaigns for rights and for equality. And it finds its origins really in the struggles encountered by professional women after 1919. And so it's very, I guess, closely linked to the event this evening. However, this event is co-hosted with the Women's Legal Landmark Project, which I guess you will be familiar with. So this is a very unique project which brings together over 80 feminist legal scholars and historians in an interdisciplinary manner in a process and in order to benchmark and to landmark key legal events, cases and statutes for the women of Britain and Ireland. And so we have the pleasure this evening, I'm going to hand over now to Professor Erica Rackley of the University of Kent, who is co-founder of the Women's Legal Landmark Project, along with Professor Rosemary Auchmuty from the University of Reading, and Erica will get things started this evening.
Hello, thank you ever so much for coming. It's really great to see you. This is, as well as being part of the LSE Women in Work, this has been the end of a series of In Conversations we've been having arising out of the Women's Legal Landmarks project. And we've been talking throughout the year about legal landmarks for women. And it came out of our project, as Orla said, which was a collaborative project. It involved many scholars, both working within the academy and outside the academy, really identifying and researching key legal landmarks for women. It ended up in this huge volume, which is now out in paperback in all good bookshops, but basically covers 93 landmarks and covers, in this centenary year, when we are celebrating 100 years of women's formal entry to the legal profession, it covers 1,000 years of women's involvement and engagement with law. Women were involved with law as litigants, as lawyers, as judges, well before 1919. And so our aim was to offer a scholarly intervention into the recovery of women's lost history by combining both our legal expertise and historical expertise to create this scholarly anthology. And we cover topics as diverse as abortion, divorce, Twitter abuse, domestic violence, representation, property, and so on, all in easily digestible 3,000 words chapters. And what we were wanting to do as part of our project was to celebrate and to acknowledge women's activism and agency within the legal sphere in terms of how they were able to use and influence law and law reform in the pursuit of justice in the UK and Ireland. We were keen and endeavoured very hard to make sure that we weren't simply repeating old myths and that were disentangled from their context or collected, as one might do, butterflies. We wanted to uncover histories that were lost in dominant accounts and to provide accounts of more recent landmarks when by talking to the people who are actually involved in them. And in an age of Me Too, or in the age of period poverty, in an age of children's food banks, where women continue to be underrepresented in public life, when women continue to be disproportionately abused in public life, it is vital that we acknowledge and celebrate the extent to which we stand alongside and on the shoulders of the women who have used and continue to use law as a powerful mechanism for justice and change. And we hope that our collection might be used to inspire current and future generations of lawyers and non-lawyers. And so for that reason, I want to do a very explicit plug, not for our book. You should read it because it's brilliant. But what you really should read is this book, which is coming out tomorrow, which is I have some leaflets which I'll make sure I hand out at the end, which has been produced by Guy Fawkes History Project in combination with Snowfields Primary School, where they're looking, and they've produced a book about women in law, and a historically accurate and important book that is really about some of the first women. The final thing I wanted to do whilst I had the floor was to say, because this is the end of our series, to say some really sincere thank yous. I realise that this often comes at the end of a presentation, but in case I don't get to say them, it's really important that we acknowledge the LSE for their support of this project, and in particular, Gillian and Maria from the library. We wouldn't have been able to do it without you over the past year. But also we want to acknowledge the Institute of Advanced Legal Studies, whose earlier hosting of our workshops and also some of our conversations was vital. But finally, we're here tonight to hear about Mary talking about her landmark, but this project came from a collective, a group of us working together and writing our individual landmarks. And so I want to publicly say thank you to everyone who was involved in our project. We've spent a lot of time this year talking about women in law, talking about the first women, and it's really important that we acknowledge that we are a collective, our project is a collective, and that we work better when we pull together rather than pull apart. So that was my pitch for the landmarks, and I will now hand over to Mary.
So we can see the slides a bit better. Lovely. Thanks.
Okay, thank you very much for having me. I'm delighted to be here. And I'm particularly delighted to be talking about this Act to you all today. I started my PhD on women in Parliament back in 2005. I finished it in 2012, and the first piece of research I ever did was actually on this Act, so it holds sort of personal significance to me, and I'm just delighted that I've managed to spend all year at the centenary talking about it. So, what is it? So this is it. The Sex Disqualification Removal Act 1919. It begins, a person shall not be disqualified by sex or marriage from the exercise of any public function, or from being appointed to or holding any civil or judicial post, or from entering or assuming or carrying on any civil profession or vocation. And what you can see pictured here is the original Act from the Parliamentary archives with the red ribbon. So that's a great opening statement. It definitely sounds like a landmark, right? What did it actually do, though? So the effect of this Act was to enable women to enter some professions, such as law and accountancy, for the first time, and also to become jurors and magistrates. It went some way to allowing women to enter the higher ranks of the civil service. It allowed women to be admitted to incorporated professional societies, and it confirmed that universities had the power to admit women to degrees. And that all sounds very positive. But when I started looking into this Act back in 2005, I found nothing but criticism from historians and lawyers alike. Historians called it a broken reed and a dead letter, identifying deficiencies and saying very little positive about it. Lawyers pointed out how rarely it had been used in court cases over 60 inglorious years, was one phrase. And this was all very damning. So where does this come from? Basically, this Act, it did things, but there were lots of things it did not do. So despite the first few words which refer to sex or marriage, which it did not remove the marriage bar. The marriage bar being the practice of requiring women to resign from paid employment on marriage in occupations such as the civil service and teaching. There were provisos in this Act, which meant that the Act did not allow women into all parts of the civil service, and women were barred from the foreign and diplomatic service in particular by subsequent regulation. And judges had the discretionary right to remove women from juries. And the Act did not tackle equality in the workplace in other ways. It said nothing on equal pay, for example, a long target of feminist campaigners before 1918 and beyond. It did not encompass politics. So it did not equalise the franchise in particular, and the Representation of the People Act passed the previous year in 1918 had given the parliamentary vote only to women over the age of 30 who met minimum property qualifications. And as well as these specific issues this Act did not address, a more general point, in the way it was drafted, the Act was an enabling Act. It allowed the appointment and holding of posts. It did not affect the employer's ability to dismiss women if they wanted, or compel an employer to give a woman a job. And the Act did not contain any enforcement mechanisms. It did not set up any commission, board or other body to monitor its work and enforce its aims, which meant that organisations and professions who chose to could simply ignore it, for example, the Church of England and the University of Cambridge. When women did attempt to use the law, they met with very limited success in courts and from bodies. For example, Lady Rhondda, who was a hereditary woman peer in her own right, tried to take her seat in the House of Lords in the 1920s, basing her claim on this Act. But it was rejected by the House of Lords Committee for Privileges. And this meant that women had to wait until 1958 to enter the House of Lords as life peers and 1963 to enter as hereditary peers. Later generations of feminists similarly found the Act was inadequate to remove sex discrimination more broadly. So just to give an example here, Shirley Summerskill MP asked a parliamentary question in 1969 about what action the Secretary of State, who was Barbara Castle, would take to enforce the 1919 Act. I think it must have been a planted question, I imagine, from Barbara Castle. The ministerial reply from Edmund Dell was, "This Act is declaratory in its effects, and that it contained no enforcement mechanisms." And so, as we know, later landmarks, some of which are in the book, include the Equal Pay Act 1970 and the Sex Discrimination Act 1975, which were necessary to further the aims of feminist campaigners in these areas. But coming back to 1919, the question I asked in my research was, if the 1919 Act was such a dead letter, why was it passed at all? What did the members of the House of Commons and House of Lords think they were doing? And when I started to look into the parliamentary passage of this Act, I found out it was not the first choice bill of the House of Commons. It was a government bill introduced to kill off a more radical private members' bill. And this, I think, helps to explain some of the dissatisfaction both at the time and since. So for the rest of my talk today, I'm going to focus on three things. Firstly, I'm going to talk about the context, the passage of the Act, how it came to pass. Secondly, I'm going to reflect on its reception, both by contemporaries and today, in its centenary, then and now, and conclude with some remarks on its importance as a landmark. So, the context. So, this is the Women's Emancipation Bill. This bill was introduced by the Labour Party on the 21st of March 1919. And you can see the image on the screen. You might not be able to read the text on the document itself. It says, "An Act to remove certain restraints and disabilities imposed on women." And although it says Act in big letters, the green ribbon gives it away. It's actually a bill from the House of Commons, and a bill being a proposed Act, a draft for discussion, debate and amendments, possibly eventually passage when it becomes an Act. The Women's Emancipation Bill contained 3 clauses: to remove the disqualification of women for holding civil and judicial appointments, and this is the part that came through and became the Sex Disqualification Removal Act, but also to include women on the franchise on the same terms as men, and to allow women to sit and vote in the House of Lords. Now, these aims were responding to campaigners, to female campaigners over decades, including suffrage campaigners, on many issues, but particularly the entrance of women to the law profession, which was the subject of unsuccessful attempts by, for example, Bertha Cave to become a barrister in 1903, and Gwyneth Bebb in 1913, which has been written about extensively by Rosemary here. So, as responding to all that, this was a private members' bill from the Labour Party. Now, in 1919, Labour were the official opposition to a coalition government. Does this sound familiar? In 1919, the coalition government was dominated by Conservatives but led by a Liberal, David Lloyd George. And what I found is that the bill passed through all its stages in the House of Commons, including against whipped government opposition at third reading. This is a remarkable achievement for a private member's bill sponsored by an opposition party. I also found that during debate, virtually all MPs claimed to be sympathetic to the first of these clauses, to the idea of women entering professions and public life. And this had not been the case before 1914. Just to give one example, Captain Loseby, an MP who was previously a schoolmaster and a barrister, cited the example of his 6 shabby genteel sisters who had options only of being governesses, nurses or schoolmistresses, which were honourable but underpaid, overworked and ill-fed professions, all other avenues being closed to them. And this was the sort of tenor of the parliamentary debate. Various MPs spoke on the suitability of women for various of these professions. And what this shows is, by 1919, the concept of women entering these professions was no longer controversial in the way it had been at the time of Bertha Cave and Gwyneth Bebb. The effects of war and the achievement of the franchise for some women had changed attitudes. A month beforehand, in fact, in March 1919, a Barristers and Solicitors Qualification of Women Bill had passed the Lords with almost no opposition. And this quote from that debate might help shed some more light on why attitudes have changed. Essentially, parliamentarians did not expect women to flood the professions, and therefore they could afford to be generous. They were, of course, quite right in that respect. However, the Women's Emancipation Bill did more than this, and when the coalition government came to look at it, it did not like it. The records at the National Archives show there was no appetite for legislating for equal franchise. It was seen as too soon, and it was, after all, the first session of the first Parliament after the previous franchise extension. And in relation to civil servants, in relation to professions, the senior civil servants expressed 2 major concerns to the government. Firstly, about women working after marriage, and secondly, about the possibility of women serving overseas. Both of these were seen as very radical, alarming and really quite impossible. The government duly decided to introduce its own bill, which took account of these points. So although the Women's Emancipation Bill had successfully passed all its hurdles in the Commons, it then moved to the Lords, where the government killed it off and replaced it with its own bill, the Sex Disqualification Removal Bill. So, as it was presented to the House of Lords and discussed in second reading on the 22nd of July, there were initially 2 clauses. Clause 1, a person would not be disqualified by sex. Marriage was then added as a later amendment, from exercising any public function or serving on juries, with 2 provisos, which were important. Proviso A, regulations might be made prescribing the mode of admission to the civil service and excluding women from certain branches. And Proviso B, judges might exempt women from jury service by reason of the nature of the evidence or the issues. The original Clause 2 would have allowed peeresses in their own right to sit in the House of Lords. This was dropped at committee stage in the Lords without division. Subsequent amendments included a phrase to ensure the admittance of women to incorporated professional societies, which you can see there. There was a new Clause 2, which allowed women to qualify as solicitors in 3 years rather than 5. This puts women, if they already possessed a university degree or equivalent, this exemption already applied to men, so put women on the same footing. And a new Clause 3 stated that universities had the power to admit women to membership or degrees. As a direct result of this, Oxford chose to admit women to degrees within a year, although Cambridge did not do so until 1948. All other universities did already admit women by this point. There was more debate on other issues, including a marriage bar, Proviso A, mixed juries, women peers, to no avail. Despite the introduction of the words "or marriage" at the start of the Act, the marriage bar continued and remained a thorn in the side of women's organisations until after the Second World War. But it is difficult to see what else could have been done in 1919. Neither the Women's Emancipation Bill nor the Sex Disqualification Removal Bill were drafted in terms of explicitly giving married women the right to work, and at the time it was thought that this phrasing would be enough. Attempts by MPs to mitigate the regulations on the civil service and on juries also failed, despite attempts. Regulations followed, reserving to men posts in the diplomatic consular services, the colonies and protectorates. The result of this was that women could not enter the diplomatic service until rules changed in 1946. Equal pay was not achieved in the civil service until 1954, and as we know, in society much later, and arguably not today. The Act did allow women to enter the higher ranks of the civil service for the first time, which was important to some women. Numbers did remain small. 3% of the total were in the top were women in the top grade in 1939. And as for the juries, rules were issued on the 12th of July 1920, which included allowing single-sex juries. And women did not serve on juries on the same terms as men until 1974. So that was the Act, and that's how it came to pass. It received royal assent on the 23rd of December 1919, so the actual anniversary is still to come, which was the last day of the Parliamentary session. Its immediate effect was quite a lot of firsts, which are too numerous to mention, but just to pick out a few. Helena Normanton became the first woman to be admitted to an Inn of Court within hours of the Act passing, and Julie became the first woman to practice as a barrister in England and Wales in 1922. Ada Summers became the first woman Justice of the Peace within a week of the Act. As Anne Logan's work has shown, this is important. Being a JP carried significant social prestige, akin to being a poor man's knighthood, as well as actually acting as a judge in courts in itself. And there were more than 3,000 women magistrates by 1948, which is a really important landmark in itself. Away from law, in accountancy, Mary Harris Smith became the first woman chartered accountant, having previously been refused admission when she applied back in 1891. I very much like to think of her sort of being vindicated all those years later. And in veterinary medicine, Aline Cust was finally recognised by the Royal College of Veterinary Surgeons in 1922. She completed her training and previously applied back in 1897. So that's another really good example of a woman who managed to sort of see it through. And for all of these women, the Act certainly was a legal landmark. The enabling power of the Act was also felt for many years to come, as institutions without much history of campaigning women found they had no excuse when women did come calling. These included, for example, the Royal Society of Arts, the British Academy and the Royal Academy. The eligibility of women for specialist work was also accepted from the start in brand new areas such as broadcasting. So that's how the Act came to pass and what it immediately did. So I'm now going to move on to talk about its reception then and now. So in terms of then, what was the reaction of feminist campaigners at the time? Now, feminist groups would, of course, have preferred the Women's Emancipation Bill to the Sex Disqualification Removal Act. Some, including Lady Rhondda, were very critical of its shortcomings, which I have outlined. Others were more pragmatic. So the 1919 annual report of the National Union of Societies for Equal Citizenship stated that half a loaf was better than no bread. You can see another quote from it here, and it's from the Women's Library here at the LSE. Of course, it was extremely disappointing that there's no equal franchise, and that did not happen until 1928. However, most women did not seriously expect the extension of the vote on equal terms so soon. So Millicent Fawcett, the great suffragist leader and campaigner, wrote that 1919 was not a bad harvest for one session, when we remember the 12 years' work necessary to get the Midwives' Bill 1902, or the 32 years of hard labour before the Nurses' Registration Bill. So you have to be realistic in what you expect. I also found out rather unexpectedly during my research that Virginia Woolf spoke very warmly of the Act less than 20 years later. In 1938, she wrote of the sacred year 1919 in her essay 3 Guineas. And you can see some quotes here. When discussing the right of women to earn a living, and Woolf is concerned here not with working class women, who of course always worked, but with middle class women, who she called the daughters of educated men. And she refers to an act which unbarred the professions. The door of the private house was thrown open, and she comes back to the date, 1919, over and over again, using it as a talisman. Now, of course, she's writing literature, not history, and the repeated use of 1919 as a device to increase her historical authority and structure her argument. Nevertheless, this device would not have worked unless 1919 meant something to her audience, and clearly it did resonate on some level to Woolf's reading public in 1938. And yet between 1938 and 2005, when I started looking into it, the Act was largely denigrated by historians and lawyers, if indeed it was remembered at all, which brings us on to sort of the contemporary era today. Because I didn't think that anyone, in 2005, I didn't expect anyone to be celebrating its centenary. Nobody remembered it, or so I thought. So I think I first became aware that people did remember it in 2012, when I was at an International Women's Day event in Parliament, and I was astounded to encounter a woman wearing a ceremonial medal commemorating 1919. And it transpired she was the chair of the Association of Women Solicitors. Now, co-founded by Carrie Morrison, the first women's solicitor in England and Wales, it was previously known as the 1919 Club and is another landmark, in fact, in the book. So I knew at that point women's solicitors celebrated the year, but perhaps not many else. But then, as the centenary started to approach, it became apparent 5 years out that the legal profession, some people in the legal profession and legal historians were indeed aware of it as a landmark for women and wanted to celebrate accordingly. And I became involved in lots of, as the only person that actually seems to know anything about the Act, I became involved in a lot of projects to celebrate it. And the ones I'm going to mention are only the ones that I have been involved in and know a lot about. There have been others. So for a start, there's this project, which Erica has already introduced, Women's Legal Landmarks. I responded to the call for this, which I think was back in 2014, 5 years out. I sort of blithely assumed that there would be no problem having this act as a landmark, since it was what the whole project was about. But in fact, it was much more a collaborative process, as Erica explained. I found it incredibly interesting to be sitting at workshops and discussing it with others and trying to hammer out exactly what did make it a landmark, especially when it was such an apparently flawed piece of legislation. I also very much supported the ethos of this project, which was that many lawyers don't know how to research history in the nicest possible way, that lawyers tend to see legal history in terms of court cases and judgments, and whereas in fact there's so much more to it. And I spoke particularly at a workshop about using parliamentary sources to research legal history, and I hope some of what I've outlined about my own research sort of helps explain why the parliamentary processes can help shed light on why things are passed and how they turned out to be what they were, and the intentions of legislators at the time, if nothing else. I was also very glad, as well as contributing the 1919 Act to this volume, I also contributed a piece on the representation of the People Act 1918, which meshed in beautifully with a lot of work on Vote 100, which I did last year. So that was that's project number one. I was also involved right from the start, from the first Women Lawyers Symposia, which is the brainchild of Judith Bourne at St Mary's University in Twickenham. Judith has organised a series of annual symposia. I spoke at the very first one on the Act back in 2015. The proceedings of that were published, as you can see here, but it's become an annual event since. I was very pleased to help host the annual event in Parliament in 2018. What this project's particularly brought is a lot of new research on some of the individual first women, some of whom are also featured in Women's Legal Landmarks, but the individual lawyers are particularly the focus of this project. It's brought to light, I think, a lot of new research, both by established historians, but also lawyers, and new scholarly work by new people in the field. So, for example, Charlotte Coleman, who did her MA project on this in 2015, Rob from Queen Mary, and Katie Broomfield from Royal Holloway, who's doing her PhD research on the early women lawyers and their entrance. She's done a whole exhibition celebrating the centenary of women lawyers as well. And I think a lot of this has come out of this project and Women's Legal Landmarks. And I should also say Judith Bourne also has written a biography of Helena Normanton and done an exhibition which I think is still at Gray's Inn on Bertha Cave. So there's been so many outputs. And a lot of these are going to be pulled together in a special edition of Women's History Review, which has just reached proof stage. I got the email about the proofs literally 2 days ago, and apparently I'm supposed to turn them around by tomorrow. Which will be, and if you want to know more, what's sort of the full scholarly, my full scholarly research on the Sex Disqualification Removal Act, it will be published in Women's History Review. Because Women's Legal Landmarks is constrained by being one piece in a very large volume. Project number 3. So this has actually come from the legal profession. First Women, the first 100 years is the brainchild of Dana Dennis Smith, and I refer you to their website for the millions of things they seem to have managed to achieve. I was one of the first project champions for this project, I think back in 2014-15 again. They've done so many things, of which this book, which was published just a few weeks ago, is one output and takes you through the full history of women in law over the last 100 years. Particularly also the podcast series I would draw your attention to. If books are less your thing and podcasts more your thing, The podcast series takes you through the last 100 years, a decade at a time. So again, I'm speaking inevitably on the Act in the very first one, but Rosemary and Erica have also been involved in the podcast series along with lots of women lawyers. And by the time you get to the most recent decade, you get Brenda Hale, whom everybody knows, of course, now talking about life, as well as Baroness Scotland. So they really have managed to get sort of the top women lawyers around today. As well as that, they've had an annual conference, and I was on speaking about the Act, of course, on the very first panel, on the very first conference back, I think, in 2015. They're creating a video interview archive. They've done touring exhibitions. They've created artworks and a new music composition, which is being premiered this weekend at King's Place. So it's been an incredibly diverse range of outputs, and I think if you look on Twitter, you'll see they're plugging the concert and with a discount code for tickets and so on. So many things, and I think the real value of this project has been engaging the lawyers. I've been to a number of first 100 years events and spoken to women lawyers who had no idea it was only 100 years, and this project has actually brought it to their attention in a way that the more academic outputs won't have done. And the Women in Law project, the Guy Fawkes project, which Erica has already mentioned. So if any of you have young children or know young children, get hold of this book. And as I say, it's being launched tomorrow. I know Courtney from Guy Fawkes quite well, and was hoping to work with her on a 2018 Women in the Vote book, which sadly never came to fruition. So I was so glad to be able to help in a very small way with her 2019 project instead. And there have been other things as well, but these are the main ones, and certainly the main ones I've been involved with. What about outside the law? Because everything I've spoken about till now has actually been about celebrating women in the law. Other professions have come on board slightly late, I have to say. But in relation to the professions generally, I was delighted that the Women's History Network annual conference, which was held here at LSE in September, and organised by Gillian Murphy, who I hope is still here in the room. Absolutely delighted that it was all themed around women in the professions. Again, I was very delighted to be a keynote speaker talking about the Act, and then to hear 2 days of wonderful papers about women in the professions, not just law, but also women accountants, women vets, engineers, nurses, you name it. Some of these enabled by the Act in 1919 and others at other times. Other professions, as I say, have come along a little later, but I know that the Institute of Chartered Accountants of England and Wales has commissioned a portrait of Mary Harris Smith, the first woman chartered accountant, so that will be nice, along with other activities, which I have not been involved with. And just last week, the president of the British Veterinary Association, a very nice woman, Daniela dos Santos, visited the Parliamentary archives to see the original 1919 Act be photographed with it for outputs that the vets are going to produce. So I'm really pleased that slightly later today, the other professions have also woken up to it. So, in conclusion, I've taken you through the Act, what it is, its context, and what's happened to celebrate it. Is it actually a landmark for women? Is all this celebration actually justified? Coming back to the history, the Act was a government replacement for a more radical bill. As such, it was a compromise. But I think the negative verdicts from earlier historians and lawyers should be balanced by consideration of three things. Firstly, all legislation is imperfect. There is no perfect Act of Parliament has ever completely met the aims of campaigners. By nature, it's a compromise. This is how you get an Act of Parliament through Parliament, by compromising. And examining the passage of the bill showed it was passed in an incredibly positive spirit. Certainly, the element about women in the professions, there was huge support shown for women entering professions in 1919 from men of very diverse backgrounds. Secondly, we must not assume standards that fail to take into account the situation in 1919. 100 years ago, the Act was passed only a year after the end of the Great War, as it was then called. The peace settlement was still ongoing throughout 1919. There was trouble in Ireland, really serious trouble, returning soldiers without jobs. The government had a huge number of other priorities, and it's frankly amazing this bill was able to progress at all. It was only a year after women had been given the limited franchise. Only a few years after suffragettes had been barracking Parliament, mere months after the first election with women voters. There was no female presence in either House of Parliament to bring pressure, yet somehow the Act was passed. And thirdly, and finally, we must not overlook the genuine achievements of the Act. And I think the centenary celebrations have brought forward new research to support this. The Act really was a significant advance on the previous situation. A barrier had been removed. Gender alone was no longer an excuse. Women were allowed to become accountants, vets, barristers, solicitors, magistrates, jurors, and so on. And this has proved to be truly powerful and inspirational today. Otherwise, we would not have seen the interest in the centenary that we have. So 1918, the year of the partial franchise, was hugely significant in terms of principle and practice. But 1919 was the year when, having put the long-running battle for the vote to one side, feminist organisations were finally able to move on to other issues, including entry to the professions. And as Woolf put it, the right of middle-class women to earn their own living. This was the first, but by no means the only achievement, as a host of other legislation affecting women's lives and gender equality was passed in the interwar period, of which this was the first. And for all these reasons, 100 years on, it's right that we remember what happened in Parliament a century ago and we celebrate accordingly. Thank you very much.
Well, thank you very much, Dr. Takayanagi. Thanks, Mary. So we have 2 book recommendations, a history review recommendation, and some listening for the Christmas holiday. So we're now going to open the floor up for questions. So there are 2 colleagues here with microphones, which we'd ask you to use because of the podcast. And if you could just indicate your name and affiliation before you ask your question, that would be fantastic. So, any questions? Nobody wants to make the first step? Yes, thank you.
Throw in a piece of information. Sorry. Can I just throw in a piece of information that might be of interest to younger members of the audience? That Mari referred to the Foreign Office having been exempted until 1948, and then the marriage bar. Well, I was in the Foreign Office, and it was 1971 before the marriage bar was lifted in the Foreign Office.
It's terrifying how recent some of these equality gains have been, and I find people just don't know. Why would you? I think it's really valuable that people like you are able to contribute that kind of information.
Thank you.
Hello, I'm Andrew, I'm a lawyer. I just wanted to ask, in the history of the Act, was it ever thought about that some kind of implementing enforcement powers were needed in the Act, or was it thought at the time, when it was being put through Parliament, that having some sort of declarative statement was enough? This is enough. Now we've made the statement, and it will implement itself, as it were, or was it thought that having some sort of provision to implement it wasn't required, that it shouldn't be put in, because otherwise you'd end up with legal cases, and that's not what we really want. What we really want is a declarative statement.
It was never considered during the passage of the Act that some enforcement mechanism should be put in. So by the time we get to the 1960s, it's becoming apparent that this is an omission. As I say, there were court cases, although not many, where women tried to cite the Act and were unsuccessful. It was thought at the time that the declaration should be enough, but sadly it was not. And I think subsequent equality legislation learnt from this. So by the time you get to the first race relations legislation in the 1960s, I think it's 65, and then built on by later Acts of Parliament, you get things like the Race Relations Board being set up. And I think the same also applies to sex discrimination and other equality legislation later on. And some of these bodies were maybe didn't have many teeth at the start, but at least they existed and could be strengthened later on. Whereas back in 1919, it wasn't thought of, and as a result, there were sympathetic MPs in Parliament who tried to push these things. I had a quote up at one point from Major Hills, who was a sympathetic MP, a Tory MP in Parliament, who really tried to push things like to not have the regulations in the civil service, for example. But it just repeatedly meant you needed to get enough supportive MPs in the House of Commons to push this, and the moment was gone. So no, sadly, it was an omission.
That's only one mic. Sorry.
I'm Rube, and I'm a sixth former. I had a question regarding the societal acceptance of the Act at the time. Would you say that the women and families at the time were prepared to fulfill the aims of the Act, I suppose?
In terms of the kind of women that this Act affected, it was middle-class women who had lacked many professions to go into, and I think one of the quotes I had up sort of explained that. In terms of women working more generally, of course, it's really important to say that some women have always worked, have had to work. You know, most women have always had to work, whether it be in the home or in employment in factories, fields, and so on and so forth. And there's never any choice about that. And so all the discussion about whether it's appropriate for women to work is very much directed at middle and upper class women. Although certainly in sort of upper middle class and upper class, there was still there was still, of course, would have been an expectation that these women would never need to work and only needed to go out and find a husband. There's quite a powerful strand of middle class women who really did need to work, you know, couldn't afford to sit home and do nothing, maybe didn't want to marry or weren't sure if they could ever marry, and really desperately needed a profession. And not all these women could become teachers and governesses, and some of them actually genuinely really did want to become lawyers, accountants, but they could only work on the fringes. And so it's not that there were no women accountants in particular before 1919, but they couldn't become chartered accountants. So as a result, the sort of salaries they could command and the fees and so on were very small. There were women working on the fringes of the legal profession, for sure, but again, only on the fringes, because if you couldn't actually become a barrister or solicitor, again, the work you could do was very limited. And the same with vets, and that those are sort of the three that I know were particularly affected by the Act. And so I think by 1919, the society had changed, of course, a lot in the wake of the First World War as well, when women had come into professions. So, of course, a lot of women worked before the First World War, but 1 million additional women entered the workforce during the First World War, doing, as we all know from film and photographs and so on, doing the same jobs as men did, to exactly the same standard, in exactly the same way, but being paid usually half as much or maybe 2/3 as much as the men were doing. But of course that had to end at the end of the war because there was a huge different societal pressure for returning soldiers to get their jobs back. And of course, you know, quite right, but this did of course mean that a lot of women were actually completely thrown out of work. And this was maybe another reason that actually it was a good idea to introduce small numbers of women, and it was thought to be small numbers of women in these respectable women in these respectable professions, and that was acceptable in 1919.
Could I perhaps ask a question, which is the Act, once it was... Sorry, I've just abused chair's privilege. I saw your hand too late. The Act, when it was introduced, was applicable in the UK and Ireland.
Yes.
Do you know what happened in Ireland after Irish independence? Because obviously the Irish constitution is not particularly... it's fairly conservative when it comes... I think that's the polite way of saying it, when it comes to women's rights.
Absolutely. So the Act completely applied in Ireland, and amongst the many talks I've given over the years, I went over to Cork to talk about this at the Irish Women's History Network a few years ago. It was passed in that sort of, you know, difficult, difficult is again a sort of very polite way of saying this incredibly difficult period of Irish history, but nevertheless a period of Irish history where definitely UK legislation applied in Ireland. This was the case after independence. Some of the female first lawyers are absolutely happening in Ireland. In fact, the first women, I've just managed to forget all their names, but I think it may even be another landmark. Some of the very earliest women lawyers to qualify in practice actually happened in Ireland rather than in the UK. Yeah. Again, because Ireland was society more conservative towards women, as you've just explained. Just as in the UK, you don't lead to floods of women entering the profession and doing all sorts of things. The progress is much slower. But like the UK, the principle is removed in 1919, and it then just takes some time to filter on. Amongst the sort of more recent discoveries I made was in fact Trinity College actually used the Act as late as, I think it was 1969, to allow women fellows, which hadn't previously been allowed in Trinity College Dublin. And at that point, they were discussing whether this was actually possible or not, and somebody went back and said, well, actually this Act does say that women should not be barred. And so it's actually being used many generations later for purposes that perhaps people didn't anticipate at the time, but it's definitely there.
Okay, thank you. Sorry, there's a question here.
Yeah, Colin Moore from the University of Essex. Just a quick question about this idea of the Act being declaratory in nature. When it was being debated in Parliament at the time, how far did they think they were going down that route? Or is it more that was the interpretation put on later? Because some of the stuff that I looked at in the 1920s in relation to women police seemed to suggest they thought it was more than that. And therefore, it changed how they thought about swearing in police, etc. But I just wondered how far in terms of what the archive tells us about how they saw it at the time.
So women police were not particularly mentioned in relation to the Act, which I think is very unfortunate, actually. But women police came in, as I'm sure you will know better than me, on a temporary basis in some areas during the First World War. And then after the war, there's a real battle to retain women police in some areas, which is, I think, successful only in part. Nancy Astor, the first woman MP to take her seat exactly 100 years ago, women police was something that she fought on for years and years. And again, I think it's a matter of you know, what's a profession? Sort of the Act removes a barrier. So yes, you could, if you're going to call the police a profession, then the Act meant that there was no bar to it. But that didn't mean that any local authority was compelled to appoint women police. And if they had women police already, there was no reason for them to necessarily keep them on. It just merely meant that there wasn't a barrier. So no one could turn around and say, it's just not possible. But then the war had kind of kind of meant that was kind of obvious anyway. But yes, the declaratory effect, I'm afraid, meant that it didn't really help women police. Unless, you know, the local authority wanted to appoint police, in which case, fantastic, they were able to do so.
Hi, I'm Rosemary Muti. Just to add to that discussion about Ireland, one of the landmarks is of the first woman law professor, and she was at Trinity College Dublin in 1925, which was very early. The first woman law professor in Britain was at Queen's Belfast in 1971, which is a lot later. And in England, she then moved to England, so she then went to Kent. So really, in this case, we've got Ireland leading the way, but it raises another issue, which is, of course, that you might have a first. Mm-hmm. But do you ever get second, third and fourth? And how long do you wait for those? Look at Brenda Hale, for example, as a classic example. So I was wondering, Mary, if you know anything about those other professions, if the entry of, you know, the first woman vet and the first woman chartered accountant was followed by nothing for decades, or did others follow? Was it substantial?
No, I don't think so. Rather like law, small numbers of dedicated women, and certainly initially the ones who'd been pushing on the door for some time, and after that numbers are quite small. I think anecdotally I've been told that the reason the Chartered Accountants have come quite late to this is because they haven't actually got a lot to be proud of. The barrier was moved 100 years ago, and then progress has actually, rather in the same way that, as I understand it, women lawyers were pigeonholed and pushed into things like family law and less into criminal law until fairly recently. I think the same has applied for women accountants. They've been pushed into areas of accountancy that you might sort of deem sort of not the sort of top tier that commands the top fees and salaries. I know less about the vets, but I'd be amazed if it was very different. I think the pattern generally is that you remove the barrier and numbers remain fairly slow and fairly small. It's the culture, of course, of these societies. And in fact, the top level of the civil service was compared at the time to a gentleman's club. And I think the same is true of a number of these professional bodies. Particularly the Bar Council and the Law Society in relation to law, the Royal College in relation to vets, the various different chartered bodies, because they differ in England and Wales and Scotland, and I'm assuming Ireland as well. That why would these bodies that have been solely had male membership for so long, and why would they suddenly turn around and encourage lots of women to? They've done it reluctantly. They've done it because they've been forced to, and consequently, it's only going to be the small numbers of really determined women. It's the same is true in politics in the House of Lords and the House of Commons. Although the first woman MP is elected in 1918, Constance Markievicz, and first takes her seat in 1919, the numbers remain tiny until 1997 in the House of Commons, and sort of similarly in the Lords. The barrier is removed, but there remain an enormous amount of cultural and societal attitudes that restrict the number of women MPs and women peers until very recently, and we're still a long way off a 50-50 Parliament. We have so at the moment we have 0 MPs because we have no MPs at the moment until the election tomorrow. But before the recent dissolution, we had about 1/3 women MPs and about 25% women members of the House of Lords. We're a long way off that 50-50 Parliament.
There's another question over here.
Hello, Unige, retired. I just wondered, Maury, if you could compare and contrast the attitudes of Oxford and Cambridge universities, and what were the specific barriers at Cambridge? Was it simply the organisational structure, or was it failure of lobbying by women students there?
I think the short answer to that is I don't really know, but I'm hoping that that the anniversary in Oxford next year will start to pull out some of the reasons why Oxford chose to act in 1920. I believe that there is a project now in Oxford to mark 100 years of women getting degrees, because of course women could study. This is another reason, ridiculous things where women could study, pass the exams and not get the degrees at the end before 1920 in Oxford and 1948, I think, in Cambridge. There was a big push, particularly in Cambridge in the early 20th century, which failed. There was a huge sort of build-up, and there's I partly know about this because there was a play called Blue Stockings, which people may have seen, which I saw at the Globe some years ago, and basically male fellows and undergraduates revolted, and it was basically, there was going to be a riot and rebellion if these women were actually allowed to take their degrees, which they'd actually been earning anyway. And I think Oxford maybe didn't have that flashpoint, and that might have made it slightly easier in 1920, that women had been more sort of under the radar, attending women's colleges or studying as home students, as it was called, and just quietly passing the exams and just not taking the degrees at the end. And because perhaps because there had been less of a sort of visible debate about it, it was actually easier for authorities to turn around in 1920 in Oxford and just say, right, okay, we're going to let women take their degrees. And one of the very first cohort of women to take their degrees is Vera Brittain, and she, I encountered this by accident in Testament of Youth, one of the books she wrote about her life, and she writes excitedly to her mother about how when she gets her degree, you'll get to see me wearing a mortarboard, and it's this sort of visible acceptance that women have been lacking for all these years, which just goes to show again part of the value placed on it, which I think we've largely forgotten today. And really, yes, that's all I know about it. Cambridge have currently got a big exhibition about women in Cambridge, which I have not yet seen, but I'm hoping to see in the new year. And again, maybe that will help shed some light on why it took so long.
Brilliant. Sorry, there's a historian in Cambridge called Susanna Gibson writing a book at the moment on the Blue Stockings.
Oh, superb.
Yeah. So there you go.
Just a quick thing on the Cambridge College thing. Was it because a lot were going to Girton that was not part of, was kind of separate from the university till 1948? Was that a factor, maybe?
Possibly, but again, I don't have the specialist knowledge about Cambridge to say. I mean, in Oxford too, there were separate women's colleges, perhaps more integrated with the university than at Cambridge, or perhaps just physically nearer, because Girton is quite... I have been there, and it is quite a long way out, so perhaps just out of sight, out of mind, whereas in Oxford, the women's colleges, Somerville, St Hilda's and St Hugh's and others at the time were much sort of physically closer.
I tried to hide that from potential undergraduates.
Well, any more questions? Oh, sorry, I didn't see.
Comment following up on the out of sight, out of mind. Newnham wasn't admitting female students then, so I think there's something quite deep in the difference between the two places. And having myself come from one of the first women's college, and it was really, really late. So my own college, New Hall, then somehow got their endowment, and that they basically plonked in the centre, but somewhere and in the 50s.
Right. Thank you. I know it's interesting.
There's a question here at the front.
Hi, I'm a student at Queen Mary, and I would like to know more about your research in terms of finding the intent of the Act. How did you research, other than the Hansard that we saw?
So, fortunately, many parliamentary sources are digitised. Hansard, with a few hideous gaps along the way, is online and free to access. And UK Parliamentary Papers is also digitised and available by subscription. And any of you with an academic affiliation can access UK Parliamentary Papers via your library subscription. And I would recommend it to anybody, whatever your subject is, however remote you might think Parliament is from your research. Parliament has had to do with everything over the years. UK Parliamentary Papers contains bills, perhaps most obviously in relation to legislation, but also things like command papers, government white papers, green papers, reports of royal commissions, and select committee reports and evidence, which are an enormous and underused source for, frankly, any kind of history. In relation to tracing acts of Parliament specifically, the main source to start with is always the journal. The journals are not all digitised and online. Recent ones will be, and some of the older ones, but not ones in between, frustratingly. But the journals are the minute book, the record of proceedings in the House of Commons and House of Lords. And whereas Hansard, it can be very unclear sometimes of what has actually formally happened. You get the speeches, but whereas the journal will always tell you first reading, second reading, third reading, committee stage, it happened then. And you can see where particularly unsuccessful bills sort of start, finish, fall, or just get abandoned and are never seen again. Hansard is then the icing on the cake, really, because that tells you what people said, and exists from the early 19th century. It's not complete record of everything until 1909, I think. There's another expert in the room who will know all about that. But after that, it is a complete record of everything said in the Commons and the Lords. From around 1919-20, you also get standing committee debates, which are the really detailed legislation debates in Parliament, and those are not online, and you have to go and find them in a library. Another really big omission. So the journal will tell you that a particular bill went to a particular standing committee, and then you can go and see if you can read the formal reports, which are not very illuminating in parliamentary papers, and then track down the standing committee debates in university libraries. And in terms of the parliamentary process, that's what you do. Because I work in the parliamentary archives, I help people with this sort of thing all the time. It should be said, though, that part of it is a lot of the sort of valuable debate happens outside Parliament. Particularly for the government side of things, you need to go to the National Archives and look at the records of whatever the relevant government department is, which might be for something like this, sort of the Home Office and the Cabinet Office, but clearly could be, whatever your relevant department is. And the National Archives has a fantastic online catalogue, and again, there's someone else in the audience who knows much more about this than me, and the staff there will help you track down the sort of government side of things. And the other source that you need to sort of really sort of round the picture is individual MPs and peers and their papers, because things like lobbying groups, you might be able to find their own archives, and so somewhere like the Women's Library is a fantastic source for the women's organisations' own archives. But in terms of how they interact with Parliament, with parliamentarians and so on, you have to look at the papers of individual MPs. We're very fortunate in Parliament to have the papers of David Lloyd George and Andrew Bonar Law, who were very prominent politicians of this time. So I was able to pick up bits and pieces from there. But actually, some things pop up in unexpected places. So we also have the papers of Viscount Stansgate, the father of Tony Benn, who was enormously sympathetic to women's causes in these periods, as a result of which all the women's organisations wrote to him all the time and sent him 3-line whip letters asking him to turn up and vote and so on and so forth. And so if you want sort of a feeling of what it was like for the members of Parliament, actually that's their own papers, wherever they survive. And again, the National Archives Discovery Catalogue is your first port of call to find out where surviving archives are anywhere in the UK.